I'm Carol Lawson, a estate planning and probate attorney in Clearwater, Florida. This webinar is on probate formal administration. Probate is the court-supervised process of administering a person's estate after they have passed away and consists of depositing the will, appointing a personal representative, marshaling the assets of the individual who has passed away and any debt, and finally distributing assets to the beneficiaries of deceased. In Florida, the probate case is filed in the county in which the person lived when they passed away. The first step in opening an estate in the state of Florida is gathering the original short-form death certificate as well as the original last will testament. The short form of death certificate does not include the cause of death, which is why it is different from the long form, which does have a section titled Cause of Death because someone's cause of death is not to be in the public record. We are not allowed to file the long-form death certificate in the probate court. If you do not have a will or do not have the original will, there is a different process that has to be followed in a probate case. If the original will cannot be located, then the state law presumes that the testator, that is the person who signed the will, intended to either revoke or destroy that will and has died intestate. Intestate succession in the state of Florida is how they will distribute your property if you die without a will in the state of Florida. In the case of a person who dies intestate or without a will, we're going to also have to file an affidavit of heirs. The affidavit of heirs is a family tree where we have to list for the court the names of various family members, their addresses if known, as well as date of death if applicable. For some people, we may also have to provide their death certificates. Once we have gone through the process of filing the death certificates and will and any affidavit of heirs, we also have to file a petition for administration with the court. The petition for administration outlines who passed away, where they were a resident of, including a list of their assets as we know them and their estimated valuation. We also will identify potential beneficiaries. If there's a will, we know the beneficiaries. If there was no will, we list the heirs. The petitioner who is filing the petition will also have to explain what their relationship is to the person who has passed away. In addition, the petitioner must also submit an oath with the court. In the oath, the petitioner must swear that they meet certain eligibility criteria in order to serve in the capacity as a personal representative and swear to this. In the state of Florida, there is a statute that outlines the requirements of a personal representative. First and foremost, they must be 18 years old. And they must state that they have never been convicted of a felony. Third, they must state, I have not been convicted in any state or foreign jurisdiction of abuse, neglect, or exploitation of an elderly person or a disabled adult. Fourth, they must also say that they are mentally and physically capable of carrying out the duties of a personal representative. And finally, they must be either a Florida resident, or if they are not a Florida resident, they must be one of the following three criteria. The first one is they are either legally adopted child or adoptive parent of the person who has passed away. Number two, related by through lineage, which means they are either a descendant, so child, grandchild, great-grandchild, or they are a parent, grandparent, great-grandparent of that individual, or a spouse, or a brother, sister, uncle, aunt, nephew, niece of a descendant, or someone else related by lineal relation of such person. So of any of those people that I just outlined specifically. And the third option, if you are not a Florida resident, is you are married to, you are a spouse of one of the otherwise qualified people that was listed. The person who is asking the court to appoint them as the personal representative of the estate must also indicate and affirm that they will faithfully administer. That is outlined in the oath. The next one is we have to appoint is the registered agent. The registered agent is going to be the attorney that you have retained to handle the case. In Florida, you are encouraged to have an attorney represent you if you are filing a probate unless it is a small probate estate. The self-help clinic at the courthouse will not help you with probate. Once you have filed the petition and the oath and the supporting documents, you're also going to submit a request to ask the judge to enter the order. The judge usually will require that a bond is posted, and if they do, what's going to happen is they will enter an order appointing so-and-so as the personal representative with a bond amount. In the order, they will say that the person has to first post the bond in a specific amount. If there is bond language in the order, then the individual is going to have to reach out to a surety and bond company, and they're going to be required to purchase a bond. After they receive the bond, we submit it to the court. Once we submit the bond to the court, we ask them to issue the letters of administration. These are court orders issued during the probate case to authorize the personal representative to begin the process of administering the estate. It basically serves as proof to the world that this person has been appointed as the administrator, and that's very important because in order to begin communicating with some of the financial institutions or whoever may hold assets of the decedent, they're going to need a certified copy of those letters, and the judge will not issue those letters until we go through all the steps to open up the probate properly and initiate the proceedings and provide proof to the judge that this individual is entitled to serve as personal representative and is capable of serving as personal representative. If there are any people who have a superior or equal right or interest in serving as personal representative, we need to send these people a waiver to execute that they will consent to the appointment of this individual. Then we have to actually provide them a notice and wait for a specified period of time for them to object if they wanted to. The next step is to file a notice to creditors. Notice to creditors. What this does is it begins the clock running on the statute of limitations for creditors to file their claim. Creditors still have a right to claims against the estate after you die. So what we do is serve the notice to creditors on any known or ascertainable creditors. These are creditors that we reasonably should know exist. So for example, if you're seeing letters from Chaz Bank and their bill is coming to the house, these are known creditors of the decedent, so we send them notice. The notice to creditors is sent by certified mail, return receipt requested, or any other method that provides for a signature upon delivery. Once you send the notice to creditors, to those known creditors, they now have a 30-day period to respond and file a claim in the probate case. If they do not file their claim within those 30 days, is barred exist. We're going to publish a notice to creditors in a local newspaper. It is actually the exact same notice to creditors we served. We start counting the 90 days from the first date of publication. The publication is actually going to be run on 2 consecutive weeks done. We count from the first day of publication 90 days. If creditors don't file their claim within those 90 days, their claim is time barred. What happens if there is a creditor that you most certainly should have known existed and you failed to give them that 30-day notice? In that instance, they have the full period of 2 years within which to file a claim. Now understand that by those 2 years, you could very well have been done with your probate case. This is why it's extremely important that when you start probate and you have a family member that you are opening probate on behalf of, it's very important that you provide the attorney with any and all known creditors, because this can be the difference between 30 days and 2 years for that creditor to come out of the woodwork and ask for their money. Once we have all the creditors, sometimes they will file claims and we deal with those claims as needed. Exempt property. We have the judge name who the new owners are of that homestead property. If there were any exempt properties involved, we also will have obtained an order from the court determining those particular assets as exempt. In Florida, you're entitled to up to value of home, household furnishings, as well as 2 personal vehicles. It cannot be business vehicles. It has to be personal vehicles. We also file a petition for exempt personal property and receive an order. Also, you need to be selling and liquidating any assets that are not going to be transferred to beneficiaries outright. So if there is a house and we're not going to sell it because we will keep that home, you may need a deed. If it is the homestead, the state of Florida, we're going to actually have an order after we file a petition with the court asking the judge to declare that home as the homestead. What that means is the homestead is exempt from the creditor's claim. The house is not going to be factored into determining whether there are assets to pay off the creditors. As long as it is determined that this house is homestead, it is going to be transferred by virtue of an order determining homestead status, entered by the judge. Once the creditor period is expired, we have our homestead order in place identifying that this particular asset is homestead. It's protected and it now is owned by so-and-so. We do a personal representative deed. There is a hierarchy of how things are paid by the estate. If there aren't sufficient funds in the estate, you may have to divide it among different classes of creditors. In Florida, we have 8 different classes of creditors in a probate case. The first class is for cost, the expense of administration, compensation of personal representatives and attorneys. Class 2 consists of reasonable funeral expenses, internment, and grave marker expenses, whether paid by the guardian, the personal representative, or any other person, not to exceed the aggregate of $6,000. You have a $6,000 cap on all of those funeral type of expenses. This class also includes end-of-life relief expenses. Class 3 claims creditors consist of debts and taxes with preference for claims in favor of the estate for unpaid taxes, court costs, fees, or fines. Class 4 claims are reasonable and necessary medical expenses and hospital expenses incurred within the last 60 days of someone's life. This is just really making sure that clinics and hospitals aren't declining to care for someone towards the end of their life when they're really seriously ill simply because they don't think they'll get paid. They now have a pretty high level of priority in the class of claims here in Florida. Class 5 claims consist of family allowance where necessary. Class 6 claims is any court-ordered child support. Class 7 claims consist of debts acquired after death by the continuation of decedent's business or maintaining the property. Those debts are only to the extent of the assets of that business or the estate. And Class 8 creditors' claims consist of all other claims, such as credit card debts. This would include those founded on judgments or decrees entered against the decedent during their lifetime, and any excess over the sums allowed in above claims for funeral expenses. If there are not enough funds remaining after the preceding class is paid, then the next class that is to be paid, it's going to be based on the proportion of their stated claim. So it's a pro rata share based on how much they are claiming they're entitled to. Once the creditor periods have expired, the 90-day period is going to be the longest one. And we've dealt with any creditor claims either by paying them, negotiating settlements of an amount less than the whole debt, or getting rid of the claim completely because there are no funds available to pay them. During this process, we also need to deal with late filed claims. Late filed claims, you will want to strike any claims that are filed late. The personal representative is required to file a signed inventory with the court within 60 days of them being appointed as personal representative. This inventory is very important because all of the beneficiaries are going to know exactly what kind of assets we're dealing with. The inventory, although it's filed with the court, it is not a public record, however. It is provided the beneficiaries. The process of closing the estate begins with filing a final accounting. The final accounting is literally what it sounds like. You're going to, again, restate what the assets of the estate were. If anything was liquidated, you're going to also indicate this was sold, blah, blah, blah. You're going to itemize the amount of compensation that has been paid to the attorney, the personal representative, and any other professionals that have been retained by the personal representative on behalf of the estate. Some estates may need a professional appraiser to determine the valuation of certain assets. You might need a CPA to assist with certain taxes that have to be filed. You may need to bring in someone to value a business. These are all people who have to be compensated in some way, and you have to let the form know how those people have been compensated. In the final accounting, you will also list any and all creditors that have been paid out of the estate funds. You will submit a plan and petition of distribution. And so this is also going to list how much is going to be paid or what is going to be distributed to the individual beneficiaries or heirs at law. Now, if you don't have consent from the people involved, then you're going to have to serve that, and they have a set period of time within which they have to object. If they don't object, then you're free to move forward, but they have to have that right to object. It's important we do not make those distributions to the beneficiaries or heirs at law until they have either waived the accounting sentence of the accounting or they have received notice in 30 days back to the period that they have to object. So once the 30-day period expires, then we can go ahead and we can start distributing the assets. When we send those distributions to the beneficiaries, if they aren't going to come to the attorney's office to pick up their check, what we do is we include a copy of a receipt and ask them to sign it. In general, most people will go ahead and sign the receipt, but I have had situations where people don't sign that receipt, and it's okay. I can use the cash check as proof that they have accepted their distribution. Remember, they didn't object within those 30 days, and now they received their payment, and they haven't objected again, and they cash that payment we can. So the court look, they consented. The process of closing the estate begins with filing a final accounting. The final accounting is where you restate what the assets of the estate are. If anything was liquidated, you're going to also indicate this was sold and the funds received. You're going to itemize the amount of compensation that has been paid to the attorney, the personal representative, and any other professionals that have been retained by the personal representative on behalf of the estate. Some estates may need a professional appraiser to determine the valuation of certain assets. You might need a CPA to assist with certain taxes that have to be filed. You may have needed to bring in someone to value a business. These are all people that have to be compensated, and you have list how those people have been compensated. In the final accounting, you will also list any and all creditors that have been paid out of the estate funds and how much they were paid. This accounting can be waived by the beneficiaries. You will submit a plan and petition of distribution. This is going to list how much is going to be paid or what is going to be distributed to the individual beneficiaries or heirs at law. Now, if you don't have consent from the people involved, then you're going to have to serve the accounting on the beneficiaries or heirs, and they have a set period of time within which they have to object. If they don't object, then you're free to move forward, but they have to have that right to object. It's important not to make distributions to the beneficiaries or heirs at law until they have either waived the accounting, they have received notice the accounting, and the 30 days to object has expired. So once the 30-day period expires, then we can go ahead and start distributing the assets. When we make distributions to the beneficiaries, we include a copy of a receipt and ask them to sign it. In general, most people will go ahead and sign the receipt. In situations where people don't sign that receipt, we are able to use the cash check as proof that they have accepted their distribution. Remember, they didn't object within those 30 days, and they received their payment, they haven't objected again, and they cash that payment, then they basically consent. At this point, we wrap up the estate by filing a petition for discharge. That petition for discharge is telling the court, look, we have administered the estate. We've paid all qualifying debt, have distributed the assets to the beneficiaries or heirs at law, and waiting for enter in order closing out the estate and relieving the personal representative of their obligations and liabilities under this probate case. That is the probate process in the state of Florida from start to finish. If you have recently lost a loved one who was a resident of Florida or died having assets in the state of Florida and you need assistance with the probate, please feel free to call me at 727-410-2705.